3 seconds. Start. Madam, there is a strong feeling among the members and they pay a tribute to the Joint Select Committee whose report is very instructive and contains dissenting opinions which I consider very valuable. But I have to make some observations because this bill raises vital issues of constitutional importance. This bill has created doubts in the public mind about the advisability of some of its provisions, and I feel that I owe it to the rule of law and to the profession to which I belong and which I have served for more than 45 years, and to this parliament that I should freely and frankly express my views and the doubts raised in the public minds so that the government may be in a position to remove those doubts. Madam, there is first the question of the determination of the age of Supreme Court judges. So far, no Supreme Court judge has raised any dispute about his age, and I have got a genuine belief that there shall never be a dispute with regard to the age of any Supreme Court judge. I feel that when future appointments are made, the government will take ample care to have sufficient proof of age. If they care, they can put down the age in the warrant of appointment or they can have declaration or even an agreement. The question then is why put an unnecessary provision in this constitutional amendment? We know that our constitution has been the subject of study throughout the world among the jurists and international organizations, and they will get the impression that after so many years of independence, some questions have been raised about the age of the judges which required constitutional amendment that will cast a reflection upon the dignity of the judiciary. If we find that there is only just a stray case or two in which the question of the age of the judge is involved, will it then be necessary to amend the constitution? When there is no case about a Supreme Court judge and no circumstance has arisen which calls for an amendment of the constitution, we must not do anything against public feeling which may even remotely cast a reflection upon the dignity of our judges. The provision regarding the determination of the age of High Court judges is important, and I believe that it deserves very careful consideration. Considerable opposition has been voiced in regard to the inclusion of persons liable to the payment of land revenue in the scheme of compulsory savings. It has also been suggested that if it is not possible to exclude this category altogether, a higher exemption limit may be fixed for them. We have very carefully considered these suggestions. May I inform the House that before the bill was drafted, there were detailed discussions with the chief ministers and finance ministers of the state, and the conclusions reached were that in a comprehensive legislation of this type, it would not be appropriate to exclude the rural sector, which has also had its fair share of rising incomes and growth in agricultural production and economy. A very large proportion of investments made by governments has been on multi-purpose river valley projects for providing irrigation and electricity facilities. The main benefit from these projects cannot be assumed to have accrued to the agricultural classes.